Section the 3rd of the Laws of England, the Municipal Law of England, or the rule of civil conduct prescribed to the inhabitants of this kingdom, may with sufficient propriety be divided into two kinds, the lex non scripta, the unwritten or common law, and the lex scripta, the written or statute law. The lex non scripta, or unwritten law, includes not only general customs, or the common law properly so called, but also the particular customs of certain parts of the kingdom, and likewise those particular laws that are by custom observed only in certain courts and jurisdictions. When I call these parts of our law leges non scripti, I would not be understood as if all those laws were at present merely oral, or communicated from the former ages to the present solely by word of mouth. It is true indeed that, in the profound ignorance of letters which formerly overspread the whole Western world, all laws were entirely traditional. For this plain reason, because the nations among which they prevailed had but little idea of writing. Thus the British as well as the Gallic Druids committed all their laws as well as learning to memoria. And it is said of the primitive Saxons here, as well as their brethren on the continent, that leges sola memoria et usu retindet. But with us at present, the monuments and evidences of our legal customs are contained in the records of the several courts of justice, in books of reports and judicial decisions, and in the treatises of learned sages of the profession, preserved and handed down to us from the times of highest antiquity. However, I therefore style these parts of our law leges non scripti, because their original institution and authority are not set down in writing, as acts of parliament are, but they receive their binding power and the force of laws by long and immemorial usage, and by their universal reception throughout the kingdom. In like manner as Aulus Gellius defines the just non scriptum to be that, which is tacito et literato hominum consensu et moribus expressum, our ancient lawyers, and particularly Fortescue, insist with abundance of warmth that these customs are as old as the primitive Britons, and continue down through the several mutations of government and inhabitants, to the present time, unchanged and unadulterated. This may be the case as to some, but in general, as Mr. Solon in his notes observes, this assertion must be understood with many grains of allowance, and ought only to signify, as the truth seems to be, that there never was any formal exchange of one system of laws for another, though doubtless by the intermixture of adventitious nations, the Romans, the Picts, the Saxons, the Danes, and the Normans, they must have insensibly introduced and incorporated many of their own customs with those that were before established, thereby in all probability improving the texture and wisdom of the whole, by the accumulated wisdom of divers particular countries. Our laws, saith Lord Bacon, are mixed as our language, and as our language is so much the richer, the laws are the more complete. And indeed our antiquaries and early historians do all positively assure us that our body of laws is of this compounded nature. For they tell us that in the time of Alfred, the local customs of the several provinces of the kingdom were grown so various, that he found it expedient to compile his Dome Book, or Liber Judicialis, for the general use of the whole kingdom. This book is said to have been extant so late as the reign of King Ward IV, but is now unfortunately lost. It contained, we may probably suppose, the principal maxims of the common law, the penalties for misdemeanors, and the forms of judicial proceedings. Thus much may at least be collected from that injunction to observe it, which we find in the laws of King Edward the Elder, the son of Offret, omnibus qui republici praesat etiam ac etiam mando, omnibus equos si prebit judices, paranesi in judicially libro scriptum habiter, nec quicquam formident quin just commune aut actor liberec dicit. But the eruption and establishment of the Danes in England, which followed soon after, introduced new customs, and caused this code of Alfred in many provinces to fall into disuse, or at least to be mixed and debased with other laws of a coarser alloy, so that about the beginning of the 11th century there were three principal systems of laws, prevailing in different districts. 1. The Mercian, Lage, or Mercian laws, which were observed in many of the Midland counties, and those bordering on the Principality of Wales, the retreat of the ancient Britons, and therefore very probably intermixed with the British or Druidical customs. 2. The West Saxon, Lage, or laws of the West Saxons, which obtained in the counties to the south and west of the island, from Kent to Devonshire. These were probably much the same with the laws of Alfred above mentioned, being the municipal law of the far most considerable part of his dominions, and particularly including Berkshire, the seat of his peculiar residence. 3. The Dane Lage, or Danish law, the very name of which speaks its original in composition. This was principally maintained in the rest of the Midland counties, and also on the eastern coast, the part most exposed to the visits of that piratical people. As for the very northern provinces, they were at that time under a distinct government. Out of these 3 laws, Roger Hovden's and Ranulph's Sessions inform us, King Edward the Confessor extracted one uniform law or digest of laws, to be observed throughout the whole kingdom. Though Hovden and the author of an old manuscript chronicle assure us likewise, that this work was projected and begun by his grandfather King Edgar, and indeed a general digest of the same nature has been constantly found expedient, and therefore put in practice by other great nations, which were formed from an assemblage of little provinces governed by peculiar customs, as in Portugal, under King Edward, about the beginning of the 15th century, in Spain, under Alonso X, who about the year 1250 executed the plan of his father Saint Ferdinand, and collected all the provincial customs into one uniform law, in the celebrated code entitled Laspartides, and in Sweden about the same era, when a universal body of common law was compiled out of the particular customs established by the lagmen of every province, and entitled the Land's Law, being analogous to the common law of England. Both these undertakings, of King Edgar and Edward the Confessor, seem to have been no more than a new edition, or fresh promulgation, of Alfred's Code or Dome Book, with such additions and improvements as the experience of a century and a half had suggested. For Alfred is generally styled by the same historians the Legum Anglicanum Condita, as Edward the Confessor is the Restitutor. These, however, are the laws which our history so often mention under the name of the laws of Edward the Confessor, which our ancestors struggled so hardly to maintain, under the first princes of the Norman line, and which subsequent princes so frequently promised to keep and restore as the most popular act they could do, when pressed by foreign emergencies or domestic discontents. These are the laws that so vigorously withstood the repeated attacks of the civil law, which established in the 12th century a new Roman Empire over most of the states of the continent, states they have lost, and perhaps upon that account, their political liberties, while the free constitution of England, perhaps upon the same account, has been rather improved than debased. These, in short, are the laws which gave rise and original to that collection of maxims and customs, which is now known by the name of the common law, a name either given to it in contradistinction to other laws, as the statute law, the civil law, the law merchant, and the like, or, more probably, as a law common to all the realm. The just commune or folk right mentioned by King Edward the Elder, after the abolition of the several provincial customs and particular laws before mentioned. But though this is the most likely foundation of this collection at maxims and customs, yet the maxims and customs, so collected, are of higher antiquity than memory or history can reach, nothing being more difficult than to ascertain the precise beginning and first spring of an ancient and long established custom, whence it is that in our law the goodness of a custom depends upon its having been used time out of mind, or, in the solemnity of our legal phrase, time whereof the memory of man runneth not to the contrary. This it is that gives it its weight and authority, and of this nature are the maxims and customs which compose the common law, or lex non scripta of this kingdom. This unwritten, or common, law is properly distinguishable into 3 kinds. 1. General customs, which are the universal rule of the whole kingdom, and form the common law, in its stricter and more usual signification. 2. Particular customs, which for the most part affect only the inhabitants of particular districts. 3. Certain particular laws, which by custom are adopted and used by some particular courts, of pretty general and extensive jurisdiction. As to general customs, or the common law, properly so called, this is that law, by which proceedings and determinations in the king's ordinary courts of justice are guided and directed. This, for the most part, settles the course in which lands descend by inheritance, the manner and form of acquiring and transferring property, the solemnities and obligation of contracts, the rules of expounding wills, deeds, and acts of parliament, the respective remedies of civil injuries, the several species of temporal offenses, with the manner and degree of punishment, and an infinite number of minuter particulars, which diffuse themselves as extensively as the ordinary distribution of common justice requires. Thus, for example, that there shall be 4 superior courts of record, the Chancery, the King's Bench, the Common Pleas, and the Exchequer ... that the eldest son alone is heir to his ancestor. That property may be acquired and transferred by writing. That a deed is of no validity unless sealed and delivered. That wills shall be construed more favorably, and deeds more strictly ... that money lent upon bond is recoverable by action of debt. That breaking the public peace is an offense, and punishable by fine and imprisonment. All these are doctrines that are not set down in any written statute or ordinance, but depend merely upon immemorial usage, that is, upon common law for their support. Some have divided the common law into 2 principal grounds or foundations. 1. Established customs, such as that where there are 3 brothers. The eldest brother shall be heir to the second, in exclusion of the youngest. And 2. Established no rules and maxims, as that the king can do no wrong, that man shall be bound to accuse himself, and the like. But I take these to be one and the same thing, for the authority of these maxims rests entirely upon general reception and usage, and the only method of proving that this or that maxim is a rule of the common law is by showing that it hath been always the custom to observe it. But here a very natural and very material question arises. How are these customs or maxims to be known, and by whom is their validity to be determined? The answer is by the judges in the several courts of justice. They are the depositaries of the laws, the living oracles, who must decide in all cases of doubt, and who are bound by an oath to decide according to the law of the land. Their knowledge of that law is derived from experience and study, from the Vigentianorum lucubrations, which Fortescue mentions, and from being long personally accustomed to the judicial decisions of their predecessors. And indeed these judicial decisions are the principal and most authoritative evidence that can be given of the existence of such a custom as shall form a part of the common law. The judgment itself and all the proceedings previous thereto are carefully registered and preserved under the name of records in public repositories set apart for that particular purpose, and to them frequent recourse is had when any critical question arises, in the determination of which former precedents may give light or assistance. And therefore, even so early as the conquest, we find the praetoritorum memoria eventorum reckoned up as one of the chief qualifications of those who are held to be legibus patrii optime institutio, for it is an established rule to abide by former precedents, where the same points come again in litigation, as well to keep the scale of justice even and steady, and not liable to waver with every new judge's opinion, as also because the law in that case being solemnly declared and determined, what before was uncertain, and perhaps indifferent, is now become a permanent rule, which it is not in the breast of any subsequent judge to alter or vary from, according to his private sentiments, he being sworn to determine, not according to his own private judgment, but according to the known laws and customs of the land, not delegated to pronounce a new law, but to maintain and expound the old one. Yet this rule admits of exception, where the former determination is most evidently contrary to reason, much more if it be clearly contrary to the divine law. But even in such cases the subsequent judges do not pretend to make a new law, but to vindicate the old one from misrepresentation. For if it be found that the former decision is manifestly absurd or unjust, it is declared, not that such a sentence was bad law, but that it was not law. That is, that it is not the established custom of the realm, as has been erroneously determined, and hence it is that our lawyers are with justice so copious in their encomiums on the reason of the common law, that they tell us that the law is the perfection of reason, that it always intends to conform thereto, and that what is not reason is not law. Not that the particular reason of every rule in the law can at this distance of time be always precisely assigned, but it is sufficient that there be nothing in the rule flatly contradictory to reason, and then the law will presume it to be well founded. And it hath been an ancient observation in the laws of England, that whenever a standing rule of law, of which the reason perhaps could not be remembered or discerned, hath been wantonly broken in upon by statutes or new resolutions, the wisdom of the rule hath in the end appeared from the inconveniences that have followed the innovation. The doctrine of the law then is this, that precedents and rules must be followed, unless flatly absurd or unjust. For though their reason be not obvious at first view, yet we owe such a deference to former times, as not to suppose that they acted wholly without consideration. To illustrate this doctrine by examples, it has been determined, time out of mind, that a brother of the half-blood shall never succeed as heir to the estate of his half-brother, but it shall rather escheat to the king, or other superior lord. Now this is a positive law, fixed and established by custom, which custom is evidenced by judicial decisions, and therefore can never be departed from by any modern judge without a breach of his oath and the law. For herein there is no thing repugnant to natural justice, though the artificial reason of it, drawn from the feudal law, may not be quite obvious to everybody. And therefore, though a modern judge, on account of a supposed hardship upon the half-brother, might wish it had been otherwise settled, yet it is not in his power to alter it. But if any court were now to determine that an elder brother of the half-blood might enter upon and seize any lands that were purchased by his younger brother, no subsequent judges would scruple to declare that such prior determination was unjust, was unreasonable, and therefore was not law. So that the law and the opinion of the judge are not always convertible terms, or one and the same thing, since it sometimes may happen that the judge may mistake the law. Upon the whole, however, we may take it as a general rule that the decisions of courts of justice the evidence of what is common law, in the same manner are as, in the civil law, what the emperor had once determined, was to serve for a guide for the future. The decisions, therefore, of courts are held in the highest regard, and are not only preserved as authentic records in the treasuries of the several courts, but are handed out to public view in the numerous volumes of reports which furnish the lawyer's library. These reports are histories of the several cases, with a short summary of the proceedings which are preserved at large in the record, the arguments on both sides, and the reasons the court gave for its judgment, taken down in short notes by persons present at the determination. And these serve as indexes to, and also to explain, the records, which always, in matters of consequence and nicety, the judges direct to be searched. The reports are extant in a regular series from the reign of King Edward II inclusive, and from his time to that of Henry VIII were taken by the prothenotaries, or chief scribes of the court, at the expense of the crown, and published annually, whence they are known under the denomination of the year books. And it is much to be wished that this beneficial custom had, under proper regulations, been continued to this day. For, though King James I at the instance of Lord Bacon appointed 2 reporters with a handsome stipend for this purpose, yet that wise institution was soon neglected, and, from the reign of Henry VIII to the present time, this task has been executed by many private and contemporary hands, who sometimes through haste and inaccuracy, sometimes through mistake and want of skill, have published very crude and imperfect accounts of one and the same determination. 3 Some of the most valuable of the ancient reports are those published by Lord Chief Justice Coke, a man of infinite learning in his profession, though not a little infected with the pedantry and quaintness of the times he lived in, which appear strongly in all his works. However, his writings are so highly esteemed that they are generally cited without the author's name. Besides these reporters, there are also other authors, to whom great veneration and respect is paid by the students of the common law. Such are Glanville and Bracton, Brigham and Fleta, Hingham and Littleton, Statham, Brooke, Fitzherbert, and Staunford, with some others of ancient date, whose treatises are cited as authority, and are evidence that cases have formerly happened, in which such and such points were determined, which are now become settled in first principles. One of the last of these methodical writers in point of time, whose works are of any intrinsic authority in the courts of justice, and do not entirely depend on the strength of their quotations from old authors, is the same learned judge we have just mentioned, Sir Edward Coke, who hath written 4 volumes of Institutes, as he is pleased to call them, though they have little of the institutional method to warrant such a title. The first volume is a very extensive comment upon a little excellent treatise of tenures, compiled by Judge Littleton in the reign of Edward IV. This comment is a rich mine of valuable common law learning, collected and heaped together from the ancient reports and year books, but greatly defective in method. The second volume is a comment upon many old acts of Parliament, without any systematic order. The third a more methodical treatise of the pleas of the Crown, and the 4th an account of the several species of courts. And thus much for the first ground and chief cornerstone of the laws of England, which is general and immemorial custom, or common law, from time to time declared in the decisions of the courts of justice, which decisions are preserved among our public records, explained in our reports, and digested for general use in the authoritative writings of the venerable sages of the law. The Roman law, as practiced in the times of its liberty, paid also a great regard to custom, but not so much as our law, it only then adopting it when the written law was deficient, though the reasons alleged in the digest will fully justify our practice, in making it of equal authority with, when it is not contradicted by, the written law. For since, says Julianus, the written law binds us for no other reason but because it is approved by the judgment of the people. Therefore those laws which the people have approved without writing ought also to bind everybody. For where is the difference, whether the people declare their assent to a law by suffrage, or by a uniform course of acting accordingly? Thus did they reason while Rome had some remains of her freedom, but when the imperial tyranny came to be fully established, the civil laws speak a very different language. Quod principi placuit leges habet vigorum, cum populus ea in iem omni suum imperium et potestatem conferre. Says Oppian, imperator salus et conditor et interpres leges existimentur. Says the codes, and again, sacrilegii instar est rescripto principis alviri. And indeed it is one of the characteristic marks of English liberty, that our common law depends upon custom, which carries this internal evidence of freedom along with it, that it probably was introduced by the voluntary consent of the people. 2. The second branch of the unwritten laws of England are particular customs, or laws which affect only the inhabitants of particular districts. These particular customs, or some of them, are without doubt the remains of that multitude of local customs before mentioned, out of which the common law, as it now stands, was collected at first by King Alfred, and afterwards by King Edgar and Edward the Confessor, each district mutually sacrificing some of its own special usages, in order that the whole kingdom might enjoy the benefit of one uniform and universal system of laws. But, for reasons that have been now long forgotten, particular counties, cities, towns, manors, and lordships were very early indulged with the privilege of abiding by their customs, in contradistinction to the rest of the nation at large, which privilege is confirmed to them by several acts of parliament. Such is the custom of Gavelkind in Kent and some other parts of the kingdom, which ordains, among other things, that not the eldest son only of the father shall succeed to his inheritance, but all the sons alike, and that, though the ancestor be attainted and hanged, yet the heir shall succeed to his estate, without any issue to the lord. Such is the custom that prevails in divers ancient boroughs, and therefore called borough English, that the youngest son shall inherit the estate, in preference to all his elder brothers. Such is the custom in other boroughs that a widow shall be entitled, for her dower, to all her husband's lands, whereas at the common law she shall be endowed of 1/3 part only. Such also are the special and particular customs of manors, of which every one has more or less, and which bind all the copyhold and customary tenants that hold of the said manors. Such likewise is the custom of holding divers inferior courts, with power of trying causes, in cities and trading towns, the right of holding which, when no royal grant can be shewn, depends entirely upon immemorial and established usage. Such, lastly, are many particular customs within the city of London, with regard to trade, apprentices, widows, orphans, and a variety of other matters. All these are contrary to the general law of the land, and are good only by special usage, though the customs of London are also confirmed by act of Parliament. To this head may most properly be referred a particular system of customs used only among one set of the king's subjects, called the custom of merchants or lex mercatoria, which, however different from the general rules of the common law, is yet engrafted into it and made a part of it, being allowed, for the benefit of trade, to be of the utmost validity in all commercial transactions. For it is a maxim of law that quo libet in suart credendum est. The rules relating to particular customs regard either the proof of their existence, their legality when proved, or their usual method of allowance. And first we will consider the rules of proof. As to Gavelkind and Borough English, the law takes particular notice of them dead, and there is no occasion to prove that such customs actually exist, but only that the lands in question are subject thereto. All other private customs must be particularly pleased, and as well the existence of such customs must be shewn, as that the thing in dispute is within the custom alleged. The trial in both cases is by a jury of 12 men, and not by the judges, except the same particular custom has been before tried, determined, and recorded in the same court. The customs of London differ from all others in point of trial. For, if the existence of the custom be brought in question, it shall not be tried by a jury, but by certificate from the Lord Mayor and Aldermen by the mouth of their recorder, unless it be such a custom as the corporation is itself interested in, as a right of taking toll, and c, for then the law permits them not to certify on their own behalf. When a custom is actually proved to exist, the next inquiry is into the legality of it. For, if it is not a good custom, it ought to be no longer used. Malice usus aboland as est is an established maxim of the law. To make a particular custom good, the following are necessary requisites. 1. That it have been used so long, that the memory of man runneth not to the contrary, so that, if any one can show the beginning of it, it is no good custom. For which reason no custom can prevail against an express act of Parliament, since the statute itself is a proof of the time when such a custom did not exist. 2. It must have been continued. Any interruption would cause a temporary ceasing. The revival gives it a new beginning, which will be within time of memory, and thereupon the custom will be void. But this must be understood with regard to an interruption of the right. For an interruption of the possession only, for 10 or 20 years, will not destroy the custom, as if the inhabitants of a parish have a customary right of watering their cattle at a certain pool. The custom is not destroyed, though they do not use it for 10 years. It only becomes more difficult to prove, but if the right be anyhow discontinued for a day, the custom is quite at an end. 3. It must have been peaceable, and acquiesced in, not subject to contention and dispute. For as customs owe their original to common consent, their being immemorially disputed, either at law or otherwise, is a proof that such consent was wanting. 4. Customs must be reasonable, or rather, taken negatively, they must not be unreasonable, which is not always, as Sir Edward Coke says, to be understood of every unlearned man's reason, but of artificial and legal reason, warranted by authority of law, upon which account a custom may be good, though the particular reason of it cannot be assigned, for it sufficeth, if no good legal reason can be assigned against it. Thus a custom in a parish, that no man shall put his beasts into the common till the 3rd of October, would be good, and yet it would be hard to show the reason why that day in particular is fixed upon, rather than the day before or after. But a custom, that no cattle shall be put until the lord of the manor has first put in his, is unreasonable, and therefore bad, for peradventure the lord will never put in his, and then the tenants will lose all their profits. 5. Customs ought to be certain. A custom, that land shall descend to the most worthy of the owner's blood, is void. For how shall this worth be determined? But a custom to descend to the next male of the blood, exclusive of females, is certain and therefore good. A custom to pay 2 pence an acre in lieu of tithes is good, but to pay sometimes 2 pence and sometimes 3 pence, as the occupier of the land pleases, is bad for its uncertainty. Yet a custom to pay a year's improved value for a fine on a copperhold estate is good, though the value is a thing uncertain, for the value may at any time be ascertained. And the maxim of law is, id certum est, quod certum rede potest. 6. Customs, though established by consent, must be compulsory, and not left to the option of every man, whether he will use them or no. Therefore a custom, that all the inhabitants shall be rated toward the maintenance of a bridge, will be good, but a custom, that every man is to contribute thereto at his own pleasure, is idle and absurd, and indeed no custom at all. 7. Lastly, customs must be consistent with each other. One custom cannot be set up in opposition to another. For if both are really customs, then both are of equal antiquity, and both established by mutual consent, which to say of contradictory customs is absurd. Therefore, if one man prescribes that by custom he has a right to have windows looking into another's garden, the other cannot claim a right by custom to stop up or obstruct those windows, for these 2 contradictory customs cannot both be good, nor both stand together. He ought rather to deny the existence of the former custom. Next, as to the allowance of special customs. Customs, in derogation of the common law, must be construed strictly. Thus, by the custom of Gavelkind, an infant of 15 years may by one species of conveyance convey away his lands in fee simple, or forever. Yet this custom does not empower him to use any other conveyance, or even to lease them for 7 years, for the custom must be strictly pursued. And, moreover, all special customs must submit to the king's prerogative. Therefore, if the king purchases lands of the nature of gavelkind, where all the sons inherit equally, yet, upon the king's demise, his eldest son shall succeed to those lands alone. And thus much for the second part of the Lage's non-scripti, or those particular customs which affect particular persons or districts only. 3. The third branch of them are those peculiar laws, which by custom are adopted and used only in certain peculiar courts and jurisdictions. And by these I understand the civil and canon laws. It may seem a little improper at first view to rank these laws under the head of Lage's non-scripti, or unwritten laws, seeing they are set forth by authority in their pandects, their codes, and their institutions, their councils, decrees, and decretals, and enforced by an immense number of expositions, decisions, and treatises of the learned in both branches of the law. But I do this after the example of Sir Matthew Hales, because it is most plain that it is not on account of there being written laws, that either the canon law or the civil law have any obligation within this kingdom. Neither do their force and efficacy depend upon their own intrinsic authority, which is the case of our written laws, or acts of parliament. They bind not the subjects of England, because their materials were collected from popes or emperors, were digested by Justinian, or declared to be authentic by Gregory. These considerations give them no authority here, for the legislature of England doth not, nor ever did, recognize any foreign power as superior or equal to it in this kingdom, or as having the right to give law to any, the meanest, of its subjects. But all the strength that either the papal or imperial laws have obtained in this realm is only because they have been admitted and received by immemorial usage and custom in some particular cases, and some particular courts, and then they form a branch of the Lage's non-scripti, or customary laws, or else because they are in some other cases introduced by consent of Parliament, and then they owe their validity to the Lage's scripti, or statute laws. This is expressly declared in those remarkable words of the statute 25 Henry 8, c. 21, addressed to the King's Royal Majesty. This your Grace's realm, recognizing no superior under God but only your Grace, hath been and is free from subjection to any man's laws, but only to such as have been devised, made, and ordained within this realm for the wealth of the same, or to such other as, by sufferance of your Grace and your progenitors, the people of this your realm have taken at their free liberty, by their own consent, to be used among them, and have bound themselves by long use and custom to the observance of the same, not as to the observance of the laws of any foreign prince, potentate, or prelate, but as to the custom and ancient laws of this realm, originally established as laws of the same, by the said sufferance, consents, and custom, and none otherwise. By the civil law, absolutely taken, is generally understood the civil or municipal law of the Roman Empire, as comprised in the Statutes, the Code, and the Digest of the Emperor Justinian, and the novel constitutions of himself and some of his successors, of which, as there will frequently be occasion to cite them, by way of illustrating our own laws, it may not be amiss to give a short and general account. The Roman law had grown to so great a bulk, or, as Livy expresses it, tam immensis alliance super alias acervitarum legem cumulis, that they were computed to be many camels loaded by an author who preceded Justiniano. This was in part remedied by the collections of 3 private lawyers, Gregorius, Hermogenes, and Papirius, and then by the Emperor Theodosius the Younger, by whose orders a code was compiled, at D. 438, being a methodical collection of all the imperial constitutions then in force, which Theodosian Code was the only book of civil law received as authentic in the western part of Europe till many centuries after. And to this it is probable that the Franks and Goths might frequently pay some regard, in framing legal constitutions for their newly erected kingdoms. For Justinian commanded only in the eastern remains of the empire, and it was under his auspices that the present body of civil law was compiled and finished by Tribonian and other lawyers about the year 533. This consists of 1. The Statutes, which contain the elements or first principles of the Roman law in 4 books. 2. The Digest, or Pandix, in 50 books, containing the opinions and writings of eminent lawyers, digested in a systematical method. 3. A New Code, or collection of imperial constitutions, in 12 books, the lapse of a whole century having rendered the former code of Theodosius imperfect. 4. The novels, or new constitutions, posterior in time to the other books, and amounting to a supplement to the code, containing new decrees of successive emperors, as new questions happened to arise. These form the body of Roman law, or Corpus Juris Civilis, as published about the time of Justinian, which however fell soon into neglect and oblivion, till about the year 1130, when a copy of the Digest was found at Amalfi in Italy, which accident, concurring with the policy of the Roman ecclesiastics, suddenly gave new vogue and authority to the civil law, introduced it into several nations, and occasioned that mighty inundation of voluminous comments, with which this system of law, more than any other, is now loaded. The Canon Law is a body of Roman ecclesiastical law, relative to such matters as that church either has, or pretends to have, the proper jurisdiction over. This is compiled from the opinions of the ancient Latin fathers, the decrees of general councils, and the decretal epistles and bulls of the Holy See, all which lay in the same disorder and confusion as the Roman civil law, till, about the year 1151, one Gratian Italian monk, animated by the discovery of Justinian's Pandix, reduced the ecclesiastical constitutions also into some method in 3 books, which he entitled Concordia Discordantium Canon, but which are generally known by the name of Decretum Gratiae. These reached as low as the time of Pope Alexander III. The subsequent papal decrees to the pontificate of Gregory IX were published in much the same method under the auspices of that pope about the year 1230 in 5 books, entitled Decretalia Gregoriae Noni. A 6th book was added by Boniface VIII about the year 1298, which is called Sextus Decretalium. The Clementine Constitutions, or decrees of Clement V, were in like manner authenticated in 1317 by his successor John XXII, who also published 20 constitutions of his own, called the Extravagantes Joannis, all which in some measure answer to the novels of the civil law. To these have been since added some decrees of later popes in 5 books, called Extravagantes Communes, and all these together, Gratian's decree, Gregory's decretals, the 6th decretal, the Clementine constitutions, and the extravagance of John and his successors, form the Corpus Juris Canonici, or body of the Roman canon law. Besides these pontifical collections, which during the times of popery were received as authentic in this island, as well as in other parts of Christendom, there is also a kind of national canon law, composed of legatine and provincial constitutions, and adapted only to the exigencies of this church and kingdom. The legatine constitutions were ecclesiastical laws, enacted in national synods, held under the cardinals Otho and Othavan, legates from Pope Gregory IX and Pope Clement IV in the reign of King Henry III, about the years 1220 and 1268. The provincial constitutions are principally the decrees of provincial synods, held under divers Archbishops of Canterbury, from Stephen Langton in the reign of Henry III to Henry Chichel in the reign of Henry V, and adopted also by the province of York in the reign of Henry VI. At the dawn of the Reformation, in the reign of King Henry VIII, it was enacted in Parliament that a review should be had of the canon law, and, till such review should be made, all canons, constitutions, ordinances, and synodals provincial, being then already made, and not repugnant to the law of the land or the king's prerogative, should still be used and executed. And, as no such review has yet been perfected, upon this statute now depends the authority of the canon law in England. As for the canons enacted by the clergy under James I in the year 1603, and never confirmed in Parliament, it has been solemnly adjudged upon the principles of law and the Constitution, that where they are not merely declaratory of the ancient canon law, but are introductory of new regulations, they do not bind the laity, whatever regard the clergy may think proper to pay them. There are 4 species of courts in which the civil and canon laws are permitted to be used. 1. The courts of the archbishops and bishops and their derivative officers, usually called in our law courts Christian, Curiat Christianitatis, or the ecclesiastical courts. 2. The military courts. 3. The courts of admiralty. 4. The courts of the 2 universities. In all, their reception in general, and the different degrees of that reception, are grounded entirely upon custom, corroborated in the latter instance by act of Parliament, ratifying those charters which confirm the customary law of the universities. The more minute consideration of these will fall properly under that part of these commentaries which treats of the jurisdiction of courts. It will suffice at present to remark a few particulars relative to them all, which may serve to inculcate more strongly the doctrine laid down concerning them. 1. And, first, the courts of common law have the superintendency over these courts, to keep them within their jurisdictions, to determine when they exceed them, to restrain and prohibit such excess, and in case of contumacy to punish the officer who executes, and in some cases the judge who enforces, the sentence so declared to be illegal. 2. The common law has reserved to itself the exposition of all such acts of Parliament, as concern either the extent of these courts, or the matters depending before them. And therefore, if these courts either refuse to allow these acts of Parliament, or will expound them in any other sense than what the common law puts upon them, the King's courts at Westminster will grant prohibitions to restrain and control them. 3. An appeal lies from all these courts to the King, in the last resort, which proves that the jurisdiction exercised in them is derived from the Crown of England, and not from any foreign potentate or intrinsic authority of their own. And, from these 3 strong marks and ensigns of superiority, it appears beyond a doubt that the civil and canon laws, though admitted in some cases by custom in some courts, are only subordinate and leges sub gravere lege, and that, thus admitted, restrained, altered, new model, and amended, they are by no means with us a distinct independent species of laws, but are inferior branches of the customary or unwritten laws of England, properly called the King's ecclesiastical, the King's military, the King's maritime, or the King's academical laws. Let us next proceed to the leges scripti, the written laws of the kingdom, which are statutes, acts, or edicts made by the King's majesty, by him with the advice and consent of the Lords spiritual and temporal and commons and parliament assembled. The oldest of these now extant and printed in our statute books is the famous Magna Charta, as confirmed in Parliament Hen. 3. Though doubtless there were many acts before that time, the records of which are now lost, and the determinations of them perhaps at present currently received for the maxims of the old common law, the manner of making these statutes will be better considered hereafter, when we examine the constitution of parliaments. At present we will only take notice of the different kinds of statutes, and of some general rules with regard to their construction. First, as to their several kinds. Statutes are either general or special, public or private. A general or public act is an universal rule that regards the whole community, and of this the courts of law are bound to take notice judicially and ex officio, without the statute being particularly pleaded, or formally set forth by the party who claims an advantage under it. Special or private acts are rather exceptions than rules, being those which only operate upon particular persons, and private concerns, such as the Romans entitled Senatus Decreta, in contradistinction to the Senatus Consulta, which regarded the whole community, and of these the judges are not to take notice, unless they be formally shewn and pleaded. Thus, to show the distinction, the statute 13 Eliz, c. 10, to prevent spiritual persons from making leases for longer terms than 21 years, or 3 lives, is a public act, it being a rule prescribed to the whole body of spiritual persons in the nation. But an act to enable the Bishop of Chester to make a lease to a bee for 60 years is an exception to this rule. It concerns only the parties and the bishop's successors, and is therefore a private act. Statutes are also either declaratory of the common law, or remedial of some defects therein. Declaratory, where the old custom of the kingdom is almost fallen into disuse, or become disputable, in which case the Parliament has thought proper, in perpetuum rei testimonium, and for avoiding all doubts and difficulties, to declare what the common law is and ever hath been. Thus the statute of treasons, 25 Edward. 3. Cap. 2. Doth not make any new species of treasons, but only, for the benefit of the subject, declares and enumerates those several kinds of offense, which before were treason at the common law. Remedial statutes are those which are made to supply such defects, and abridge such superfluities in the common law as arise either from the general imperfection of all human laws, from change of time and circumstances, from the mistakes and unadvised determinations of unlearned judges, or from any other cause whatsoever. And this being done, either by enlarging the common law where it was too narrow and circumscribed, or by restraining it where it was too lax and luxuriant, hath occasioned another subordinate division of remedial acts of Parliament into enlarging and restraining statutes. To instance again in the case of treason, clipping the current coin of the kingdom was an offense not sufficiently guarded against by the common law. Therefore it was thought expedient by statute 5 Eliz. C. 11, to make it high treason, which it was not at the common law, so that this was an enlarging statute. At common law also spiritual corporations might lease out their estates for any term of years, till prevented by the statute 13 Eliz, before mentioned. This was therefore a restraining statute. Secondly, the rules to be observed with regard to the construction of statutes are principally these which follow. 1. There are 3 points to be considered in the construction of all remedial statutes: the old law, the mischief, and the remedy, that is, how the common law stood at the making of the act, what the mischief was, for which the common law did not provide, and what remedy the Parliament hath provided to cure this mischief. And it is the business of the judges so to construe the act, as to suppress the mischief and advance the remedy. Let us instance again in the same restraining statute of 13 Eliz. C10. By the common law, ecclesiastical corporations might let as long leases as they thought proper. The mischief was that they let long and unreasonable leases, to the impoverishment of their successors. The remedy applied by the statute was by making void all leases by ecclesiastical bodies for longer terms than 3 lives or 21 years. Now in the construction of this statute it is held that leases, though for a longer term, if made by a bishop, are not void during the bishop's continuance in his see, or if made by a dean in chapter, they are not void during the continuance of the dean. For the act was made for the benefit and protection of the successor. The mischief is therefore sufficiently suppressed by vacating them after the determination of the interest of the grantors. But the leases, during their continuance, being not within the mischief, are not within the remedy. 2. A statute, which treats of things or persons of an inferior rank, cannot by any general words be extended to those of a superior. So a statute, treating of deans, prebendaries, parsons, vicars, and others having spiritual promotion, is held not to extend to bishops, though they have spiritual promotion, deans being the highest persons named, and bishops being of a still higher orders. 3. Penal statutes must be construed strictly. Thus the statute 1 Edward, vi. C12, having enacted that those who are convicted of stealing horses should not have the benefit of clergy, the judges conceived that this did not extend to him that should steal but 1 horse, and therefore procured a new act for that purpose in the following year, and, to come nearer our own times, by the statute 14 Geo. 2. C6. Stealing sheep or other cattle was made felony without benefit of clergy, but these general words, or other cattle, being looked upon as much too loose to create a capital offense, the act was held to extend to nothing but mere sheep, and therefore, in the next sessions, it was found necessary to make another statute, 15 Geo. 2. C34. Extending the former to bulls, cows, oxen, steers, bullocks, heifers, calves, and lands by name. 4. Statutes against frauds are to be liberally and beneficially expounded. This may seem a contradiction to the last rule, most statutes against frauds being in their consequences penal. But this difference is here to be taken, where the statute acts upon the offender, and inflicts a penalty, as the pillory or a fine. It is then to be taken strictly, but when the statute acts upon the offense, by setting aside the fraudulent transaction, here it is to be construed liberally. Upon this footing the statute of 13 Eliz, c. 516, which avoids all gifts of goods, and c. made to defraud creditors and others, was held to extend by the general words to a gift made to defraud the queen of a forfeiture. 5. One part of a statute must be so construed by another, that the whole may stand, ut res magis velat, quam perit, as if land be vested in the king and his heirs by act of parliament, saving the right of an has at that time a lease of it for 3 years. Here shall hold it for his term of 3 years, and afterwards it shall go to the king. for this interpretation furnishes matter for every clause of the statute to work and operate upon. But 6. A saving, totally repugnant to the body of the act, is void. If therefore an act of Parliament vests land in the king and his heirs, saving the right of all persons whatsoever, or vests the land of it in the king, saving the right of it, in either of these cases the saving is totally repugnant to the body of the statute, and would render the statute of no effect or operation, and therefore the saving is void, and the land vests absolutely in the king. 7. Where the common law and a statute differ, the common law gives place to the statute, and an old statute gives place to a new one, and this upon a general principle of universal law, that legis posteriors priors contrariis abrogate, consonant to which it was laid down by a law of the 12 tables of Rome, that quod populus postremum jicit, aegis radum estum, but it is to be understood only when the latter statute is couched in negative terms, or where its matter is so clearly repugnant that it necessarily implies a negative, as if a former act says that a juror upon such a trial shall have 20 pounds a year, and a new statute afterwards enacts that he shall have 20 marks. Here the latter statute, though it does not express, yet necessarily implies a negative, and virtually repeals the former. For if 20 marks be made qualification sufficient, the former statute which requires 20 pounds is at an end. But if both acts be merely affirmative, and the substance such that both may stand together, here the latter does not repeal the former, but they shall both have a concurrent efficacy. If by a former law an offense be indictable at the quarter sessions, and a latter law makes the same offense indictable at the assizes, here the jurisdiction of the sessions is not taken away, but both have a concurrent jurisdiction, and the offender may be prosecuted at either, unless the new statute subjoins express negative words, as that the offense shall be indictable at the assizes, and not elsewhere. 8. If a statute that repeals another is itself repealed afterwards, the first statute is hereby revived without any formal words for that purpose. So when the statutes of 26 and 35 hen. 8. Declaring the king to be the supreme head of the church were repealed by a statute 1 and 2 Philip and Mary, and this latter statute was afterwards repealed by an act of 1 Eliz. There needed not any express words of revival in Queen Elizabeth's statute, but these acts of King Henry were implicitly and virtually revived. 9. Acts of Parliament derogatory from the power of subsequent parliaments bind not. So the statute 11 hen. 7. C1, which directs that no person for assisting a king de facto shall be attainted of treason by act of Parliament, or otherwise, is held to be good only as to common prosecutions for high treason, but will not restrain or clog any parliamentary attainted cause the legislator, being in truth the sovereign power, is always of equal, always of absolute authority. It acknowledges no superior upon earth, which the prior legislature must have been, if its ordinances could bind a subsequent parliament. And upon the same principle Cicero, in his letters to Atticus, treats with the proper contempt these restraining clauses, which endeavor to tie up the hands of succeeding legislators. When you repeal the law itself, says he, you at the same time repeal the prohibitory clause, which guards against such repeal. 10. Lastly, acts of Parliament that are impossible to be performed are of no validity, and if there arise out of them collaterally any absurd consequences, manifestly contradictory to common reason, they are, with regard to those collateral consequences, void. I lay down the rule with these restrictions, though I know it is generally laid down more largely, that acts of Parliament contrary to reason are void. But if the Parliament will positively enact a thing to be done which is unreasonable, I know of no power in the ordinary forms of the Constitution that is vested with authority to control it, and the examples usually alleged in support of this sense of the rule do none of them prove that, where the main object of a statute is unreasonable, the judges are at liberty to reject it, for that were to set the judicial power above that of the legislature, which would be subversive of all government. But where some collateral matter arises out of the general words, and happens to be unreasonable, there the judges are in decency to conclude that this consequence was not foreseen by the Parliament, and therefore they are at liberty to expound the statute by equity, and only quod hoc disregard it. Thus if an act of Parliament gives a man power to try all causes that arise within his manner of Deo, yet if a cause should arise in which he himself is party, the act is construed not to extend to that, because it is unreasonable that any man should determine his own quarrel. But if we could conceive it possible for the Parliament to enact that he should try as well his own causes as those of other persons, there is no court that has power to defeat the intent of the legislature, when couched in such evident and express words as leave no doubt whether it was the intent of the legislature or no. These are the several grounds of the laws of England, over and above which equity is also frequently called in to assist, to moderate, and to explain them. What equity is, and how impossible in its very essence to be reduced to stated rules, have been shewn in the preceding section. I shall therefore only add that there are also peculiar courts of equity established for the benefit of the subject, to detect latent frauds and concealments, which the process of the courts of law is not adapted to reach, to enforce the execution of such matters of trust and confidence as are binding in conscience, though not cognizable in a court of law, to deliver from such dangers as are owing to misfortune or oversight, and to give a more specific relief and more adapted to the circumstances of the case than can always be obtained by the generality of the rules of the positive or common law. This is the business of our courts of equity, which however are only conversant in matters of property, for the freedom of our Constitution will not permit that in criminal cases a power should be lodged in any judge to construe the law otherwise than according to the letter. This caution, while it admirably protects the public liberty, can never bear hard upon individuals. A man cannot suffer more punishment than the law assigns, but he may suffer less. The laws cannot be strained by partiality to inflict a penalty beyond what the letter will warrant. But in cases where the letter induces any apparent hardship, the crown has the to pardon.